Good evening, it's Vanessa Varga from Varga Lawyers. I'm speaking to you tonight from our Modbury office. So we've had quite a number of posts today in relation to a query, which I'll read again. So as I understand the query, the question is, I'm wondering two things. Can you leave a larger share of your estate to one child over another without having to provide a reason? And can you recommend anyone locally? So the first question is, can you leave a larger share of your estate to one child over another? Many of the comments there have been helpful and some have been incorrect. So the answer is, it's your will, your assets. You can do whatever you like with your assets. So yes, you can leave someone a larger share, but there are things that you need to be aware of if you're going to do that. So in South Australia at the moment, we have the Inheritance Family Provision Act. And under that legislation, certain categories of people can make claims on your estate in the event that you don't leave them adequate provision. So it might be a child, it might be a partner, there are other persons who can make claims, and some of those people who can make claims have to qualify and meet certain criteria. On the 1st of January next year, we're going to have a new act. It's called the Succession Act. And under the Succession Act, we are broadening the eligibility of people who can make a claim by introducing claims by adult stepchildren. So this is very controversial and contentious, and we now have the ability, as of next year, for adult stepchildren to make claims. At the moment, adult stepchildren cannot. Only stepchildren who were maintained at the date of death by the deceased at the moment can. I wanted to speak through some of the answers that we've had today on the page. So someone said wills can be contested for up to 6 months. So when a grant of probate is made after someone dies, then that's when the clock starts ticking. You have 6 months to issue and serve your claim on the executor. An inheritance claim is a claim that you can make if you've been left without adequate provision for your proper maintenance, education and advancement in life. So what all that means, because that's the language in the legislation, is if you're in financial need effectively. And to assess that, we look at the assets that the beneficiaries have and the size of the estate. One theme that keeps coming up, and I've seen it a lot, is that, if you leave someone a small amount, say $100 or, 15%, someone else said, then they can't make a claim. Well, that's not true. Anybody can make a claim if they're eligible and if they can satisfy the court that whatever they've received is not enough. And I find that if you leave a small amount to people in your will, you're basically just waving a red flag to a bull, because you're saying, here's a little bit, and one, you're now notified that I'm dead, and two, you're notified that you're receiving something in the will which you're probably not going to be happy with. So that will permit the person to then issue the claim within time. If you're estranged from someone, don't leave them anything in the will. They might not even know you've died. Time might run and expire, and then they might lose their right to make a claim. So even though we've got this 6 months time limit, which somebody identified in the posts, you can get an extension of time to issue and serve your claim on the executor. It depends on a number of factors. So it's not absolutely blanket rule. There is a time limit, but there is the right in the legislation to apply for an extension. So tokens do not prevent claims being made. You're better off leaving them either nothing or leave them with adequate provision. And the only other way to avoid a claim is to die with no assets. So if you have your assets in someone else's name or in a financial institution like a company or a trust, another resource, then potentially you can avoid a claim. But I don't recommend people go around and transfer their assets out of their name. You'll probably have stamp duty consequences, potentially capital gains tax. This is all a part of when you come and see a specialist, identifying what's best for you and your family and looking at the pros and cons. Let's see what else you've said today. So you can do anything with your will, leave your assets however you like. Somebody said, I think that if someone's going to contest your estate, then it's best to leave a reason or an explanation for your wishes. Under the new legislation, one of the main considerations is that the testator's wishes is now going to be the primary consideration. So definitely, if you're leaving someone out, write a letter about what has happened and why you've chosen to do that. Make sure the letter's with your will. Pop a paragraph in your will about why you're not naming them in your will as a beneficiary. This can all be helpful under the future legislation. As of today, not so much. It definitely doesn't prevent claims because one of the main considerations at the moment is, has the person been left without adequate provision? Also notice that some people were talking about the magistrates court. So in South Australia, the jurisdiction for deceased estates is the Supreme Court of South Australia. So all these types of claims are made in the Supreme Court, and the only judges who have authority are justices of the Supreme Court in respect of these final decisions, unless some of the masters have been given authority and are wearing an auxiliary justice hat. So that's probably it insofar as answering your question. I'm happy to answer any other questions. I have been on ABC Radio a couple of times, and we've put that in the Varga Lawyers link. And I'll continue to be on ABC Radio in the future, answering any questions that you might have and call through with. But I'm also happy to answer your questions on the social media platform of Facebook. So I hope you guys have a great night and hope that was helpful. Thanks.